What key clauses belong in your partnership agreement? Imagine building a house without a blueprint. You might end up with a structure that doesn't stand. The same goes for a business partnership. A solid agreement is your blueprint. It helps prevent disputes and keeps everyone on the same page. When disagreements happen, having clear clauses can make resolving conflicts much easier. So, what should you include in this important document? First, you need to clearly state who the partners are. Write down their full legal names and what roles they will play in the business. This makes it clear who is involved and what they are responsible for. Next, define what the partnership is all about. Describe the business purpose, the kind of work you will do, and the legal structure of the partnership. This sets clear expectations from the start. It's also important to specify how much money or assets each partner is putting into the business. This is called their capital contribution. Include each partner's ownership percentage based on their contributions. This helps determine how profits and losses will be shared later on. Speaking of which, you should clearly explain how profits and losses will be divided. Will it be equal or based on ownership? Will partners get salaries or just share the profits? Decision-making is another key area. Decide who has the authority to make what decisions. For example, some decisions might need everyone's approval, while others can be made by one partner. Clarify each partner's responsibilities and roles. This avoids confusion about who does what and helps prevent conflicts over work. Dispute resolution clauses are vital. Include steps for resolving disagreements, like mediation or arbitration, before going to court. This saves time and money. Also, plan for bringing new partners into the business. Outline how they will be admitted, what they need to contribute, and how their ownership will be calculated. You should also prepare for what happens if a partner wants to leave, becomes unable to work, or passes away. Include buyout procedures, valuation methods, and restrictions on competing after leaving. Buy-sell provisions are also important. They specify how a partner can sell or transfer their interest, giving other partners the right of first refusal. Protection clauses like non-compete, non-solicitation, and confidentiality are essential. They prevent partners from competing with the business or sharing sensitive information after they leave. Make sure these restrictions are reasonable in scope and time. Finally, include details on how the partnership will be managed day-to-day. Set rules for meetings, record keeping, and financial reporting. Also, state how long the partnership will last and under what conditions it can be dissolved. Wrap up with miscellaneous provisions like governing law, how to amend the agreement, and indemnification clauses to protect partners from certain liabilities. Having these key clauses in your partnership agreement creates a clear legal framework. It helps prevent misunderstandings, reduces the risk of costly disputes, and provides a plan for resolving conflicts if they arise. A well-drafted agreement is the foundation of a successful and smooth-running partnership.